live.
All right, welcome to the House Judiciary Committee this Thursday morning, April 23rd, and we're going to turn back to S208, but kind of a fairly major development yesterday. Ninth Circuit ruled, and we're going to hear about this from our legislative counsel momentarily. Yesterday, preliminary injunction enjoining California's similar rule that we have in the statute. We'll get into the details, but I think this kind of changes the decision points that we have in this committee on this particular bill. I mean, it is a different circuit. You know, if we can, what I'm planning on doing myself is looking very closely at this ruling and the reasoning behind it and how solid that is, how different our bill is from that. It is a separate, you know, we do have a different circuit. And we're not bound by that rule at this point. But I think we need to make a decision of whether to proceed when this would obviously be litigated and what is the chance of it being found constitutional. I think we all need to make that decision after hearing from experts. So the other question is, even if we decide that we're not going to do this statutorily, should we have Criminal Justice Council proceed in having a model policy for identification and masking? So that's kind of a separate discussion of whether we would want that, even if we don't proceed with the statutory component of this. So with that, we'll have Sophie come and fill us in on the Ninth Circuit opinion, and then also walk through of the latest draft of the bill, so we kind of know where the bill is at this point as well. So thank you for being here, and thank you for your work on this.
You're welcome. Good morning, Sophie Zadatny for the Office of Legislative Counsel. And I'm assuming you want me to talk about the Ninth Circuit decision first.
Yeah, do that.
Okay.
And then we'll walk through the latest draft.
Right. I did a quick PowerPoint. I always find sometimes displaying
PowerPoint already on it?
displaying a PowerPoint can be a little tricky, so bear with me here. Let's give it a go. Yeah. Okay. So when this bill first came over from the Senate, I sort of went through and did a quick PowerPoint on the constitutional issue. So this is just a really streamlined version here. But this is ultimately what's going on at the Ninth Circuit, right? Is the constitutionality of two similar laws. So as a quick refresh, in California, they had two bills. They had a no secret police bill and they had a no vigilantes bill. And the no secret police was their anti-masking bill, and the no vigilantes bill was the identification bill. And at the district court level, so the trial court level in California, struck down the anti-masking bill, not on the grounds that it regulated the federal government, but on the grounds that it discriminated because it didn't include California state police. And so California legislators were like, well, we'll just, go back and we'll add them in. So that's maybe happening legislatively there. But the displaying identification bill moved ahead and was appealed by the United States, by the government, to the Ninth Circuit. And it was, as happens at the Circuit Courts of Appeal, it was assigned to a 3-judge panel. And I think when I came in the first time, we literally had just gotten the decision from the district court. And now today, we literally just got the decision from the Ninth Circuit. So I'm just going to briefly run through this. So again, this is the supremacy clause. So this is really where sort of constitutionally where we're looking, which provides that constitutional laws of the United States are the supreme law of the land. And last time we talked about Vermont's police powers and the 10th Amendment. But this case in California is focused on the intergovernmental immunity doctrine. And so this was established back in 1819. And providing that the states have no power by taxation or otherwise to retard, impede, burden, or in any manner control the operation of the constitutional laws enacted by Congress to carry into execution the powers vested in the general government. And there hasn't been a ton of case law around intergovernmental immunity sort of since then. So this is a relatively new area that these cases are in. And so the doctrine holds there are two prongs. The federal government is immunized from state and local laws that either regulate the United States directly or discriminate against the federal government and those with whom it deals. So again, the anti-masking bill had gotten struck down on that second prong because of the discrimination piece. And so the question in front of the Ninth Circuit was focused on, does the visible identification statute that was passed in California, does that regulate the United States directly? And the district court had held that no, it didn't, that requiring law enforcement officers to display their identification was the same as like a traffic law or whatever. It wasn't burdensome. It was just simply, wasn't interfering with their ability to get their job done. So the California district court held for both, because it would have upheld the anti-masking bill, but for the fact that it had the discrimination piece in. So they held it did not interfere with or control federal law enforcement operations, and they analogized it to traffic laws. Yes, according to the Ninth Circuit. So this was the three-judge panel yesterday. They held that Section 10 of the bill, the No Vigilantes bill, attempts to directly regulate the United States in the performance of governmental functions. And Section 10 was the bill that has the visible identification. Just give you a quick summary of that. So just quickly, yeah, they at the district court level, and this is relevant because of the policy piece. At the district court level, the United States had also challenged the policy requirement. So in the California law, there was if agencies, law enforcement agencies, develop policies and they publicly posted those and maintained them, then if you were a law enforcement officer for that agency, you wouldn't be subject to the criminal penalties. That was not appealed up to the Ninth Circuit. The district court upheld that the United States did not have standing to contest that. So it was only the Section 10 that went up to the Ninth Circuit. And Section 10 provided, again, it has.
Sorry, can you repeat that last part one more time?
Yeah, so Section 2 of the No Vigilantes Act was the one that dealt with policies. So under the California law, they had said that if a law enforcement agency, whether state or federal, had developed a policy and then they maintained that, publicly posted it on their website, then if an officer was found in violation of the law, they wouldn't be held criminally liable.
Okay.
And the United States had contested that. They contested Section 2 and Section 10 at the district court level. And the district court held that the United States didn't have standing to challenge that policy piece of it. And that was not contested at the Ninth Circuit. So at the Ninth Circuit, they were just looking at Section 10. And Section 10 requires any non-uniform federal law enforcement officer operating in California, with narrow exceptions, to visibly display identification while performing federal law enforcement duties. And the exceptions that they characterize as narrow are going to be somewhat familiar to the committee: plainclothes operations, active undercover or investigative activities, personal protective gear that prevents display, exigent circumstances such as imminent danger to persons or property, escape of perpetrators, destruction of evidence, including if the officer is off duty, SWAT or tactical teams, and protective operations. So if somebody's protecting a judicial officer or an elected official. And so what the Ninth Circuit held was there's no de minimis exception to the intergovernmental immunity doctrine. So in other words, it doesn't matter how small, they're still going to say no. So if a state law directly regulates the conduct of the United States, it's void, irrespective of whether the regulated activities are essential to federal functions or operations, and irrespective of the degree to which the state law interferes with federal functions or operations. And then finally, this is where the Ninth Circuit came down. States can impose general rules regulating conduct that any citizen may perform, so like traffic laws, but the Supremacy Clause does bar, and the emphasis on direct is in the decision, direct state regulation of the federal government, and that is precisely what the No Vigilantes Act does. So essentially, the Ninth Circuit just found that this is directing sort of how federal law enforcement operations are being conducted in California.
So it seems to me, though, that they're ruling on Section 10. I mean, Section 2 doesn't say that at all.
Right.
Yeah. I mean, the fact that they have this policy or would allow feds to get away from the criminal penalties because by having a policy, that doesn't seem like that.
And they didn't talk about the criminal penalties at all. Like there was no weighing of, well, because you're imposing a criminal penalty, this makes this, makes us more inclined to rule against the law. There's no discussion of the criminal penalties.
So we can't, state legislators can't tell the feds to adopt a policy. And they can't have it that, okay, this is what's going to happen unless you adopt a policy, right? That's kind of the same thing.
Right. That would be my understanding. And again, so I mentioned last time that 3 other states in the interim from the previous time I talked to you had passed similar laws. So 2 of those, Washington and Oregon, are also in the 9th Circuit. And then the other one was New Jersey, which is in the 3rd Circuit. So we're here in Vermont, we're in the 2nd Circuit Court of Appeal. So again, this wouldn't necessarily be binding on the 2nd Circuit, although they would be aware of it, they would look at it, and they may decide whether they agree with it or not. There's, as far as I know, and I didn't look again this morning, but California has a couple of options. I mean, they could ask for the whole of the 9th Circuit, sort of en banc, to review the decision. They could try and go to the Supreme Court. I don't know that the Supreme Court would take it at this point because there's no circuit split. There's just one decision that's out of the 9th Circuit. And this is still essentially, as you mentioned before, this was basically enjoining the enforcement of this statute pending sort of complete resolution of the case. So this is interim, but they basically have found that the United States would be irreparably harmed if they didn't award the injunction because they believe that it's unconstitutional. So
has there been a lawsuit brought in against the New Jersey law? Do you know?
I don't know off the top of my head. The other 3, Washington, Oregon, and New Jersey, were all passed in late March. So I definitely saw news stories that from statements from a federal official saying they intended to oppose it, but whether there's been a lawsuit filed, I could double check and see. I don't know off the top of my head.
And what's the status of other states in the 2nd Circuit and whether anybody is proceeding with what you're, if you could find out for us.
Yeah, no, I did do
Right, you did give us.
I did go through, so let me just have a quick look. Just looking at the other states that are here in the 2nd Circuit. Well, New York, as you know, because the statute originally, the basis for the original bill was based on the New York statute, and that has not yet moved forward. And then the other one would be Connecticut, and Connecticut doesn't have a pending bill.
Right.
So in the 1st Circuit, Massachusetts has a bill out there. New Hampshire does not, and Maine does not. So Massachusetts would be kind of our nearest. Yeah.
Massachusetts does have a bill.
They have a bill that's under discussion, not passed.
Okay. So one last question that I have, and if other folks have questions, how is it possible to distinguish the bill that we have from what was struck down, or at least the preliminary injunction stage in California?
I think it would be challenging, is my view, only because, I mean, they talk about non-uniformed officers. Ours was more general, but the exceptions are similar. The 9th Circuit characterized their exceptions as narrow. We've got more exceptions. I think the exceptions that are in ours are pretty broad, but again, it's more that language that they had at the end in terms of sort of there's no de minimis exception, gives me pause.
Right. So any other questions?
Yeah, I think I have one. How often does I guess I'm thinking the term rocket docket, but that's not really the right word. The 3-judge panel over the full court. How often are those decisions different if it's taken to the full court?
I don't know off the top of my head, and I'm not familiar with the 3 judges that were on this panel. One of the other attorneys in Legislative Council, when she saw who the 3 judges were, indicated that she thought it was a pretty conservative panel.
Yeah.
But the 9th Circuit is today very different than it was even a few years ago. I mean, it used to be known as sort of one of the more liberal circuit courts of appeal, and I don't think that that's necessarily the way it's viewed at this point.
How is the Second Circuit viewed?
I think I don't think on either end of the spectrum. That's my sense. So just my personal sense. Yeah. I mean, they do shift over time, but I don't, like the Fifth Circuit is viewed as pretty conservative. The Fourth Circuit used to be incredibly conservative. I was in West Virginia and it was definitely viewed as a very conservative court, but that has definitely changed over time.
Mm-hmm.
Yeah, interestingly, the two most conservative judges when I clerked there have they look liberal now. Wilkerson and, well, Ludig is,
Right.
it's kind of interesting. Yeah, sorry. Go ahead.
Yeah, the ninth, you said is you think it's more conservative than it used to be, but how much did it move? I mean, if there's 10 clicks to the middle and it moved one click.
No, I think it's moved pretty much, I would say, to the middle.
Okay.
Yeah, that's, again, this is just, haven't been out litigating
No,
in cases
I appreciate
recently,
it.
but that is my sense is that the Ninth Circuit it definitely was viewed historically as being very liberal, but I don't think it is viewed that way anymore.
And I think, I mean, I haven't had a chance to read the case, and I mean, some cases seem to be more political than others, but this is kind of interpreting constitutional law, and it's the intergovernmental immunity clause, and I think might be relatively straightforward, but until I think we all should read the opinion. It's not that long.
No, it's 16 pages.
Yeah, and we'll get more testimony on what folks think. I mean, certainly I will tell you where I'm leaning already is that I don't think that we should be pushing this. I think it's probably not constitutional, but I'm open to being persuaded otherwise by witnesses. But I think why don't we go ahead though, nevertheless, we may as well go and hear or walk through the latest draft of this. And then we have a couple of witnesses to hear from as well.
It's the Ninth Circuit opinion.
Correct.
Okay.
Yeah. It doesn't try to deal with the Ninth Circuit opinion.
Yeah, and I would say, I mean, historically, there just haven't been that many cases on intergovernmental immunity, so they tend to look back at these sort of cases from like, the 1920s and stuff. So this is a new area for federal courts to wade into. Okay. Oops. Okay. All right. So this has some changes on it from when we last went through the draft. That's there we go. So the changes are highlighted as we go through, and some of these came from editing. So I had GATOR here, and editing preferred Gator mask. So the GATOR Gator was from the Washington statute. On this, there had been some questions. So this is to do with identification requirements. And there was a provision, a law enforcement officer shall verbally disclose in a clear and audible manner the officer's name and the official name of the officer's agency when detaining or arresting an individual. And there was a question about, how do you do that, in the moment? So this adds in as soon as it is practical and safe to do so. And that's language that comes from current immigration regulations. So right now, under the Code of Federal Regulations around when ICE officers are making arrests, this is language that is contained in that regulation that they're required to identify themselves as soon as it's practical and safe to do so. And then this gets into the exceptions. It's combined. Before there was an A and a B. One was for active undercover and one was for plainclothes. And the request was to just combine them into a single one. So it's now during active undercover or plainclothes operations. And then using such as instead of a double including. And then these were largely changes, again, from editing the while wearing, while responding, while performing, while engaging. And then we get into the facial covering requirements. So there was a testimony last time regarding this extreme temperature piece has always been a challenge for how to sort of come up with something that doesn't swallow the whole rule, but provide some guidance. And there was testimony last time regarding weather conditions, not simply on the cold end, but also on the hot end. So this now provides a facial covering designed to protect against exposure to adverse weather conditions, taking into account the actual temperature, wind chill, and then adding in humidity and length of time of the exposure. So it's aiming to capture both ends of the spectrum. And this was just some renumbering the highlights on that initial bit, and then a correcting for a second offense or a subsequent offense. Before that was an and. And then there are two new sections here. So under penalty, so again, right now, if the law enforcement is found to have violated either the anti-masking or the identification piece, for a first-time offense, they'd be assessed a civil penalty of not more than $1,000, and for a second or subsequent offense, not more than $2,500. And then this now provides subsection 2. This subsection shall not apply to a law enforcement officer if the officer's employing law enforcement agency has adopted and publicly posted a written policy consistent with the requirements of this section, and that provides for administrative action to be taken for violations of subsections C and D of this section. So that essentially means that, you know, I think that the term was double jeopardy was used, which we know is not the correct legal term, but the fact that a law enforcement officer could face both a civil penalty and face disciplinary action through the Criminal Justice Council. And so this, if the officer's agency has a policy and they've adopted a policy, they would then just be going down the administrative route and would not be subject to the civil penalties. And then finally in G, this is a new subsection. This is an inseverability clause. So typically we have under state law in statute 1 VSA section 215, any state law that you pass has by default within it a severability provision, which means that if a court were to find a piece of one of your bills, your statutes to be unconstitutional or whatever, that can be stripped out and the rest of the bill would continue. So what this is saying is the opposite of that. It's notwithstanding the severability provision. If any provision of this section is declared unconstitutional or the applicability of this section to any personal circumstance is held invalid, the remaining portions of this section shall be rendered invalid. So in other words, if a piece of this bill were to be held to be unconstitutional, then the whole piece is, rather than just that single piece.
Go ahead there.
Yeah, so I guess that last part kind of gets at what my question was. So did the California law have an severability clause?
No, not that I recall.
So theoretically, the provisions within the section 10 of that law still apply to state and local. Okay, so with the inseverability clause in here, if we were to move forward and it were to be found unconstitutional, then the applicability to state and local would not apply either,
Right.
because the whole thing would be found.
Right.
All right, any other questions for Sophie? Thank you very much, and thank you for the quick work on the explanation on the Ninth Circuit opinion as well. So we'll go to Sean Burke next. If you could join us. Good to see you, Chief Burke.
Good morning. Good to see you as well, and other committee members. Thanks for having me in this morning. So appreciate the time this morning to give some testimony on S208. So my name is Sean Burke. I do have the privilege of serving as the interim chief of police in the city of Burlington. I've been a Vermont municipal police officer for the last 32 years. I am currently the president of the Vermont Chiefs Association, and I want to be clear that I am testifying on behalf of the association this morning and not on behalf of the city of Burlington. Interesting development, of course, with the constitutionality of the bill. The association has the opinion that this isn't really a matter for a state statute in Vermont, but rather a matter for policy, individual agencies. The city of Burlington's had a longstanding policy of officers wearing name tags and having distinct badge numbers throughout their career here while they serve in the city of Burlington, which is a little unique to us. Not everyone operates that way. In light of that, I do appreciate the changes that were made to the proposed bill, the officer's name or unique radio or badge number. That's very helpful for Vermont law enforcement. We do still identify a challenge in section C1, subsection B, where the officer's agency or initials of the officer's agency be displayed on the officer's person at all times. You know, many of us have to work in the rain or wear traffic vests. We buy them typically from large suppliers of this gear. Not everyone invests the money in screen printing to have the actual agency put on a traffic vest or a raincoat. So we see this as an unfunded challenge potentially with the bill. In terms of identifying ourselves at the time of arrest or detaining someone, again, appreciate the improvements here as soon as practical and safe to do so. You know, we see this is reasonable. It's woven into a lot of our different policies to include traffic stops and other police enforcement activities. We still see this as a bit of a challenge, though, and it can be awkward. You know, even when I worked in my career started in Woodstock, it's a small town. Often you didn't have to identify yourself as to who you were as a Vermont law enforcement officer working in that community. Even when I came to Burlington, I worked the old North End for 4 solid years. Didn't need to identify myself. So, you know, I think appreciate what's going on nationally with federal immigration operations. Of course, we're front and center in that arena right now. Understand the negative reverb with the public, but as an association, we really don't see this as a challenge that our communities are facing with their police departments. The other section I'd like to address briefly in C is 3A. Again, improvements here in terms of plainclothes operations, but this is largely geared toward investigative activities. I mean, many police departments here in the state employ detectives. They do, in fact, wear plain clothes. They typically are, you know, carrying their badge with them, but don't wear name tags. I will say, as an administrator coming up through from the rank of lieutenant and above, oftentimes I'm asked to engage with community groups, and they ask that I not wear a uniform. And some of these examples date way back before 2020, when there was such consternation about police and community relations. American University, that was once held here by AALV, they would have us in to talk to new immigrant community about what the police do and how police and government, you know, differ from potentially from countries those folks had come from. And often it would be in plain clothes. Fast forward to today, I am constantly asked to speak at any number of community convenings, and it's not uncommon to have a request from the public to come in plain clothes. And I think that's reasonable, and I try to accommodate it. I'd hate to see a statute that really prohibits us from being responsive to our individual communities and neighborhoods within. So just some feedback there. And then lastly, I think, you know, the cleanup on the penalties, again, this is helpful in terms of saying if an agency has a published policy that we can regulate the employee performance or compliance with that, whatever's prescribed in that policy. But that really brings us back to our opinion as an association that this does not need to be codified in statute. We can advance this work on a policy level and actually look across our policy manuals in their entirety, because I know there's bits and pieces of carrying identifications, how you identify yourself during stops, and we can make it you know, more consistent. So when looked at through a procedural justice lens, Vermonters can know what they can expect from us. But in no way can we promise through either state statute or policy what Vermonters can expect from federal agents. And with that, I'm happy to take any questions.
So I just one question, and then I'll open it up to other folks. So if we get to the point where essentially the bill becomes subsection E, which is on page 4, which is the statewide policy, would that be beneficial for having a statewide policy for consistency of process? You know, leave it to the Criminal Justice Council through their process for coming up with policy, and leave it at that. But what's your input on that? Yeah, if that's value to do that.
So I think in this, I appreciate the question, Chair Lalonde. I think, defining helpful is challenging because we don't hear, these calls from our communities to have local law enforcement operate different in this arena, but rather federal agents, and we just can't reach that far. So, if this were to be studied by, say, the Criminal Justice Council, maybe laid over the code of conduct that's kind of new. That model policy is definitely new, and then other areas of model policy to see if improvements need to be made. But I don't think we need to rush to this, but that's the opinion of our association and of course myself as a practitioner.
So is it a matter of a January 1st, 2027 date or just having a mandate from the legislature requiring this kind of policy?
No, we always respect, the wishes of the General Assembly and direction that they want to provide, of course. I do think that January 1, 2027 is a short runway for something. This policy work takes time. It's always easy to say, let's create one. And then we realize like all the different agencies, entities, and mission sets that lie within that. And then how do you kind of standardize that across? It's super, even in an organization like Burlington PD, it's easy to say like, okay, in uniform, we're going to wear this name tag, this badge, and this is how you're going to speak to someone on a traffic stop, right? It's easy to do. But then when you try to apply that to what our detectives are doing in general crimes versus narcotics versus sex crimes, it gets convoluted. You lay that across the law enforcement enterprise in the state of Vermont, and it gets very convoluted, and it'll take some time to kind of suss out where we need this specific guidance for identification.
So a possibility could be rather than a new policy, but to request that the Criminal Justice Council incorporate where appropriate into the code of conduct identification and masking standards, something along those lines. But we can work on that if that's the direction we end up going. Tom, and then Ian.
Morning, Chief.
Morning.
Looking at the evolution and why we've had this evolution on this bill, and obviously some of my reluctance to it, and the change in what's happened today, I've sort of been thinking more along the line. I'm not saying we need to dismantle this whole thing, but I would like to suggest maybe something more instead of policy, but the academy taking the reins and helping with some sort of best practice that they could, or maybe a committee could put together something that would apply to, detectives. So you should get kind of, obviously we can't contain every particular scenario. I don't think we could create enough of them to cover this. And so I think the attempt is to try to fill the hole with a practice instead of a policy. How do you feel about that?
Yeah, I mean, I think that's a good strategy. I still would like to identify, is this really a problem for Vermont law enforcement?
Right.
This feels like it is a state initiative looking to address, again, the actions of the federal government, which seems to be a bridge too far. And, I think of all the things that I hear, all the feedback that I hear here in the city of Burlington, which I think is a decent barometer of, what's good and what's bad with policing. This isn't what we're hearing about our staff.
I agree with you. Thank you.
Ian.
Thanks, Chief. Yeah, this is very helpful. I just want to understand, so are there departments in Vermont currently that don't have a policy related to identification or masking?
Identification, I can't say that every single police department does. Even the Vermont Chiefs, we get X amount of participation from our members.
Yeah.
Identification, though, is consistent. Uniform operations are consistent. Masking is likely inconsistent, but again, like masking is usually purpose built, and I think what is laid out here in the bill actually is a decent resemblance of how police departments use masks within the state of Vermont. Like we do, in fact, here in Burlington, we do have a policy on masks, and full facial coverings aren't allowed unless it's protective in nature. But I can't say that every police department has, that type of guidance. And one other plug that I'll make is I think every municipal police department in the state, with the exception of Burlington and South Burlington, are insured by the league. And the league has a policy manual for all of its members that they insure. And perhaps the league could provide a little more visibility on what each agency has in terms of.
Thank you.
Yeah. Barbara.
Good morning, Chief Burke. Great to see you. I was thinking when we originally took up this bill, I was looking at some of the recent cases in Vermont. I know there was one of somebody impersonating a police officer. And my concern, so this in a way seemed like, oh, that's great. Not that someone's doing that, but like in terms of trying to address that. So I'm wondering if we go the direction that you're suggesting, if there is sort of a public education component of what should somebody ask if they, don't see identification or questioning if it is a law enforcement officer.
Yeah, certainly. I think, we've kind of dealt with this issue for a long time. And in fact, probably some folks even remember in the Upper Valley years ago, there was some crimes committed on the interstate corridor, which made nurses traversing there nervous. Certainly here in Chittenden County, we've had people that we've attempted to stop on a traffic stop, and they'll call the dispatch to say, like, I don't know what to do. And we'll direct them to, a gas station canopy somewhere. So, and, broker that we are the police. When I was once a detective and you're knocking on someone's door and they say, I don't know if you're really a cop, I'll have them call the station and say, yes, this guy is a cop, engage with him as you'd like to. But to bring it really back to contemporary times, what we did more recently for our immigrant community here in the South, in the city of Burlington, was we took pictures of our uniform and insignia and shared that with all of our partners to get that, information out to the community so they could quickly discern what a Burlington police officer looks like as opposed to whatever they may be confronted with at their doorstep or in the community.
It's really helpful. The other thing is, it sounded like at the public hearing, some people had concerns about state police identification. And I would have to go back and look at the hearing testimony again, but I don't know if you recall that, or obviously if that would be addressed through the policy.
Yeah, I would leave that whatever went on state police on the public safety to address.
Yeah, so I've had the chance to read the Vermont State Police After Action Report on the March 11th. I haven't had a chance to read South Burlington's yet, and I understand Burlington's is coming soon, or from what I understand. And I know that after that event and at the public hearing, there were concerns about identification and masking, and I guess that's in part motivating me to at least have policy or practice or something like that, not just let it drop entirely, to try to, ease concerns that there are out there that, in fact, our law enforcement are going to follow appropriate practices. But I don't know if yours is going to identify or address that issue. It was addressed a little bit in the state police after action report, but that's kind of in part what I think motivates having something, some requirement for policy or practice on masking or identification. So if you want to comment on that.
Yeah, just a high level reflection. I know that the state police on scene that day that had masks are part of a specialty team, so that that's would be allowed here. What's proposed,
Right.
And the Burlington police officers on scene were not masked, and that is our posture. But if we had to have officers mask for some protective reason as an employer, we would do so, because we are, we're beholden to keep our staff safe, and certainly our insurance carriers would not want us, stating any policy or practice where first reports of injuries, debilitating injuries would be then levied against the city and our insurance carrier, and also, harm our precious number of sworn officers that we do in fact still employ here in Burlington.
Right, understood, absolutely. I just think if there was somewhere that law enforcement can point to that we are in fact following best practices. We're not doing this for illegitimate reasons, and having that out could be helpful. But all right, so any other questions for people? Yeah, go ahead.
I don't know if I got any questions or not, but we're talking about this, policy and practice, or maybe having it taught at the academy and things like that. And I wish I could remember exactly what we did years ago, but we had a situation, again, I don't remember exactly what it was. And what we had done is left it up to whatever the department was to remedy the situation and then come back and report to us. And to me, it seems like this is potentially one of those situations, is to leave it up to DPS, I guess, on some level, or and to come up with what will work for law enforcement in the state of Vermont as far as these issues go. As far as people coming in here that we've heard from, giving testimony and being witnesses and speaking against Vermont law enforcement, it's a pretty short list if there's anybody on the list at all. And everybody in here, on the committee, whether you're for, in favor or against this bill, every person has said that this has been geared toward the feds. And nobody has said it's been geared towards state law enforcement. It's even been said that basically that state law enforcement is collateral damage because of the feds. So I would certainly be in favor of and I don't know the exact way to do it, but whether it's directing or asking, DPS to come up with policy, practice, whether it's taught at the academy, that type of thing, because everything I've seen and heard, law enforcement in the state of Vermont has been above and beyond doing the right thing, and to force them into doing something that is frankly micromanaging what they do. When we're getting into telling law enforcement what they can do or not do when it comes to humidity level, that is a little above and beyond what we should be doing. So I would certainly support leaving it up to law enforcement, DPS, and whoever, to putting in a policy and practice and coming back and reporting to us. No question for you, Chief.
So that's actually a good segue probably to talk to Christopher Brickell about how the Criminal Justice Council could address this, either through their code of conduct or practice or policy. If you could just weigh in on that issue. Christopher, thank you very much for being here. Identify yourself and you can weigh in.
Morning, Chair. Yes, Christopher Brickell, the Executive Director of the Vermont Criminal Justice Council. I appreciate the opportunity to testify on this current draft of the legislation that I'm seeing. And I think what I'd like to do, if this works for the committee, is just present some of the challenges that I see in this, and then maybe offer some suggestions along the lines of the conversation that I've been hearing among the committee this morning. Understanding that the initial intent of this legislation was really meant to address, I believe, the problems with the federal government that folks were seeing and in fear of happening. The first challenge right off the bat is in the definition section of this, where we define a law enforcement agency, which has the same meaning as statute, which is fine. But then defining law enforcement officer is the only area in which a federal law enforcement officer is included in the definition. So if you go back to some of the other language in this bill, it refers to the law enforcement agency, which would not encompass the federal law enforcement officer that the intent is actually looking to, I think, try to address. So that's the first challenge, but law enforcement officer definition within this bill does include and encompass what a federal law enforcement officer would be. Where I don't feel is appropriate is to address all of the attempts to modify and single out the occasions where it would be appropriate or not for a law enforcement to mask. I think that there are several in here that have been incorporated, but then likely some that haven't even been thought of yet, or that would become problematic. And as well as with the identification piece, which I think was appropriately addressed by Chief Burke. Where I do see the real next challenges for the council would be under the statewide policy on the bottom of page 4. What that requires is us to establish a statewide policy. And if that's a statewide policy and there was a violation of that policy, that would be a category B violation of Act 56. And what that would require, that's under the unprofessional conduct statutes. So that would require, if a complaint came to us at the council based upon a violation of this statewide policy, our statutory mandate is to first send that complaint back to the agency that employs that individual officer, and they have to conduct an internal affairs investigation that once completed, they send the results to us for review. An agency is not going to investigate if the complaint is about a federal officer, nor would we accept a complaint against a federal officer because we don't govern federal officers. We don't certify federal officers. We only certify Vermont law enforcement officers. So those would be the only people that the council would have jurisdiction, if you will, over their certification status. And the only certification people that we would have the authority to take any type of action over, if that makes sense. So what I'd like to get down to is one more just piece into this is that if this was also required for the Vermont Criminal Justice Council to create a statewide policy, the subsection on page 5 on line 10 is the problematic piece for us. So this is basically a carve out that says, if a law enforcement agency has adopted and publicly posted a written policy that's consistent with the requirements of this section, that allows for them to take administrative action. So if the council was required to create a policy, the only way that we would be able to hold agencies compliant with such a policy would be for us to actually receive copies of those policies from each agency, go to each of those agencies on a compliance check to make sure that they had a written, publicly posted policy. And how is that defined? They actually have a written policy in their office. Is it posted on their website? When was it posted? When was it taken down, modified? That would be extremely problematic from a compliance standpoint for the council to try to monitor and make sure that agencies were in compliance with. As opposed to the challenges that I'm mentioning here, which I think are, again, problematic, what I'd like to offer is a different solution to this, which would be not necessarily for the Vermont Criminal Justice Council to create a policy, but for this topic to go to the LEAB, or the Law Enforcement Advisory Board. And I'll tell you the reasons why, because the composition of the Law Enforcement Advisory Board has many of the participants in the law enforcement community but also includes the Attorney General's office and others that have guidance within the law enforcement community. They're public meetings that are held so that the public can weigh in on those meetings. And those are the best folks really to have engaging in this conversation about what should the policy entail, what should it not entail, who does it encompass, and how is it most effectively implemented. In addition to that, the whole purpose of the Law Enforcement Advisory Board is to provide recommendations to the Commissioner of Public Safety, but also the Governor and the General Assembly on best practices for law enforcement. And it's a mechanism for the General Assembly to know that the work that you're concerned with is being addressed and being reported back for approval. And if there was a real concern about Vermont law enforcement agencies violating such a policy or this behavior becoming problematic for the citizens that they interact with, then this could become a statewide policy that the council could adopt. And then it would fall under the Act 56 requirements that if there was a violation, there could be potential sanctions against an officer for that. All of that said, I don't think any of that will impact a federal agency.
So, first we have to evacuate the building.
And evacuate the building and using the designated route or area for the close stairwell or exit. Designated area. Checking fire and
Send your ideas in email, that would be great, or we'll try to get back to you.
I can do that. Thank you.
May I have your attention, please? May I have your attention, please? Evacuation, gather your belongings if they are within reach, and evacuate the building and using